People v. Emmanuel Almonte.
Good afternoon, Your Honors. May it please the Court. My name is David Robles, pro bono counsel for the defendant appellant Emmanuel Almonte. With the Court's permission, I'd like to reserve 2 minutes for rebuttal.
You have it.
Thank you, Your Honor.
So if I can start you right where I started on the last case about lesser included, what is your reasonable view of the evidence that the defendant's injuries here were caused by anything other than a gun?
Your Honor, there was no gun recovered in this case, and by the complainant's own admission, he tumbled down multiple flights of stairs, came into contact with...
Did he did anybody say that the head hit his head and cracked it open?
So
the stairs hit his head and cracked it open?
The complainant never said that.
And he was cross-examined on that?
He was not cross-examined about that point.
So what's the evidence that the stairs caused the crack in his head?
The complainant testified that he came into contact, that he fell down the stairs, and that he came into contact with the stair railing. And the standard here is whether they're, as the Court knows, viewed in the light most favorably to the defense.
Well, can you be very precise about the testimony? Because I thought he said he threw himself down the stairs, not that he was thrown by the defendant, and that he clung to the railing, but not that he hit his head on the railing. Am I wrong?
Your Honor, he said that he did say that he threw himself down the stairs, that he was dragged down the stairs, and that he did hang on to the railing. And at one point, he says that he's hit with a gun against a pole. And when asked specifically, the doctor who treated him, when the doctor was asked specifically whether a stair railing could have caused these injuries, she couldn't rule that out.
Well, no medical witness is ever going to, unless they happen to be an eyewitness, be able to tell you precisely how it happened. Because, they're asked these questions to a reasonable degree of medical certainty typically. And so I'm not really sure that her testimony gets you anywhere. And the only testimony we really have about what happened in the stairwell is the witnesses. So the question comes back to exactly what Judge Wilson is asking and what I've been asking, which is, what's the evidence beyond speculation that would make it, a reasonable view of the evidence to say that there's a lesser included that should have been charged here?
Your Honor, this was, by the complainant's own admission, a messy altercation, and the jury here sent up a note asking specifically whether the stairs or the railing could be a dangerous instrument. And I would respectfully suggest
that was actually in response to something that they were invited to consider in the summation by defense counsel. And so my question is, when the judge is evaluating, before that happens, whether to give a charge, what is the evidence that the judge should have looked at and that was, pointed to by defense counsel requesting the charge that would support it?
Here, when defense counsel specifically asked for the jury to be instructed on assault in the third degree, the judge paused and said, "That is interesting. I need to consider that," and then made a ruling to not include assault in the third degree without any explanation. Defense counsel specifically said that, quoting the medical expert, that any sharp edge, whether metal, wood, or glass, could have caused these injuries. The only testimony, the only evidence of a gun in this case comes from the complaining witness. There is no gun recovered. There's no video.
That's not recovered because the arrest doesn't happen for a day and a half.
So
counsel,
let's
I think you'd have a
start
stronger
with
argument if the police had responded immediately.
counsel. What's the standard that we have to apply?
The court should look at the evidence in the light, look at the record in the light most favorable to the defendant and determine whether there's any rational basis for the
So what's speculative if the jury chooses to discount that a gun is used, doesn't believe that part of it? What's speculative about a person being dragged up and down a flight of stairs several times, throwing himself down a flight of stairs? What's speculative about an inference that maybe along the way they hit their head?
There is, I would respectfully say, there is nothing speculative about that. This is,
Does anything in our case law say that someone expressly has to say that during
No, it doesn't.
testimony or with medical documentary evidence?
It does not.
But
And
whereas here you have the victim stating affirmatively that this is what happened. I was hit with a gun, and said a whole lot of other things. What I think we have said that yes, generally you can accept portions of testimony and reject others, but you can't, where there's an overall consistency and no reason to question, you can't parse testimony piece by piece. So to me, this seems a little bit like parsing his testimony, and what would be the basis for doing that, where he himself, he has an opportunity to say anything about what happened. He could have said, yeah, and I hit my head when I fell down the stairs, anything, and doesn't. He says, they hit me with a gun. That's why I was bleeding and I needed stitches. So what is the basis for parsing that testimony in that way?
so here, Your Honor, it wouldn't be arbitrary or irrational, which is, I believe, the language that the court used in Scarborough to talk about parsing out testimony. Here, the complainant himself says he goes down the stairs, he's dragged down the stairs, he's hit against the railing. And so, and again, the standard here is just, is there any rational basis for the jury to have believed that he committed assault in the third degree?
You're saying that there's a testimony by him that he hit his head on the railing?
Yes,
Where
Your
is that
Honor.
in the record?
There is. He says that he was hit with a gun against the pole.
And are you further saying that he actually testified in this record that he hit his head on the stair?
He does not say I hit my head on a stair clearly, but we know from that the jury had a view here and was concerned and had serious concerns about whether a gun was involved at all in this case.
Right, and that, as I said earlier, I think is in response to the summation, which is fair, given that there was no objection that the summation was departing from the evidence. But if I can, I want to change your focus to the issue about the excited utterance, and in particular, in our particular jurisprudence as it stands now, do we look at any one factor as dispositive, or do we look at the totality of the circumstances to determine whether something is an excited utterance, such as, whether there's still a stimulating event, the time that's passed for reflection, and all the other factors that have been mentioned in our case law?
So I believe under Edwards, the decisive factor, the determinative factor, is whether the surrounding circumstances show that the declarant was exercising reflective capacity when the statement was made.
Okay, and is there a time limit on that?
There is none. No, there's no specific time limit. In this case, Your Honor, and I would respectfully suggest that this court's decisions in People v. Cantave and People v. Vasquez compel the result that this call was improperly admitted before this call even takes place. The attackers have fled the scene. The declarant has gone into his home, had a conversation with his mother about the event, and by his own admission on the stand, has chosen not to tell his sister what's going on because he made a decision that it was better off that she didn't understand.
It seems, though, that your argument there's two parts to the incited utterance argument, the way I understand it. First is, did the court abuse its discretion in letting it in? And secondly, you make an argument that the incited utterance exception should be abolished as a policy matter. Let's assume that the first part is preserved. Personally, I think it was, but there may be disputes about that. But let's assume the first part is preserved. It's a tough standard to say he abused his discretion here. So even though you get to the issue in front of us, how do we say that this was an irrational decision by the court?
What the court did here, if in analyzing the call, the court just looked at the call itself in isolation.
Let me ask you this. So you're the judge. Well, what I would say, I'd look at it and say, well, how long was it between the events? Would we be saying as a matter of law that this 10-minute gap would be enough to say that the incited utterance exception shouldn't be allowed in here?
No, Your Honor, we wouldn't be.
So we shouldn't rely on the time exclusively.
Correct.
What should we rely on? What other factors?
In this case, the court should rely on the fact that the declarant was in his apartment, his attackers had fled, he's responding to questions, he's not just blurting things out unprompted, and look at the cases in, for example, in People v. Vasquez, where there was a similar situation in which the declarant was alleged to have been hit with a gun,
I'm sorry, finish.
goes into his home, speaks to his mother, and answers questions from a 911 operator. And this court found that even though the declarant sounded agitated and was upset for the next 24 hours, that the declarant possessed reflective capacity, and therefore the call wasn't an excited utterance.
The singular most important thing, which is to say who these people are, since he knows them personally, when did he reveal that information?
The declarant is asked, and I see my time is up.
Please answer that question.
The declarant is asked a series of questions aimed at eliciting the identity of his alleged attackers. He's known by his own admission, he's known the defendant his entire life. They dated the same girl. And despite being asked all of those questions, doesn't say who they are. Immediately after the call, he goes on a canvass of the neighborhood with police officers to look for the alleged attackers, and again, doesn't disclose their identity, doesn't disclose their address.
He does say he knows them.
He does say he knows them.
He doesn't give their names.
He doesn't, which in our view, Your
Does
Honor.
he ever give their names?
He gives their names 24 hours later.
Okay, thank you,
Did the
counsel.
911 operator ask the name?
She did not, but she asked a series of questions about it. Thank you, Your
Thank you.
Honor.
Judge Rivera, may I?
Oh,
may I
yes,
have
sorry,
one more?
I'm sorry.
I'm sorry.
Judge Wilson has a question.
I wanted to know, let's assume this is error. Why isn't it harmless on the following theory? The court says we're not going to admit this. Victim takes the stand, says there was a gun, gets cross-examined about whether there really was a gun, and on redirect, the prosecutor says, didn't you tell the 911 operator that there was a gun? And then introduces the statement to rebut essentially the cross-examination. This is fabricated. Why doesn't it come in anyway?
This call wouldn't come in. This wasn't a prior consistent statement. That wasn't the scenario.
As to the gun.
In this case, correct.
Right. As to the gun.
Correct. And what the prosecution did here was essentially hang its hat on this call. Now, we are unaware of any court that has ever ruled that, particularly this court, and the prosecution certainly hasn't cited any cases in which improperly admitted hearsay was cured through cross-examination or the harm was even lessened. And so this call wouldn't have come in under any circumstance. Our view is that the call wouldn't have come in under any circumstance and wouldn't have come in as a prior consistent statement either.
Thank you.
Thank you.
Good afternoon, Your Honors. May it
Counselor?
please the court.
Did we recently say that this question of whether it's an excited utterance is a mixed question of law and fact?
That's correct, Your Honor. This is a next question of law and fact that
So do we have to find that there was error in admitting this statement as a matter of law if there's record support for the trial court's finding that the victim had time for reflection?
No, Your Honor. The scope of review at present is limited to whether or not there was record support for the trial court's conclusion, and we submit that there was ample support for that determination. The minimal amount of time that passed between the assault and the call, the seriousness of the injuries, the fact that the victim was bleeding profusely from his head, and the tone and tenor of his complaints on the call, his foremost and paramount concern on securing medical attention as quickly as he could, as well as as well as what was transpiring in the background. A listening of the tape reveals that the victim's mother was audibly distressed,
Yeah, well, what's also revealed is that he's obviously talking to other people, the sister and the mother, before he's making any comments to the dispatcher, that when he has the opportunity to provide key information to identify his attackers, because he knows them personally, he doesn't. Doesn't that go against, this is, to me, not a question of mixed question of fact and law, except all the factual determinations of the judge about what is being said on the call and the time that expires. The question is whether or not what appears to be calculated choices means that this particular individual had time to reflect and make decisions that then take it outside of the framework of the excited utterance exception.
We would respectfully disagree. On the call, it's apparent that the victim's foremost concern is obtaining medical attention. As he continues to voice his complaints, his ailments, his need for medical attention, the dispatcher, understandably, but nonetheless interrupts him to ask more pointed questions, more investigatory questions aimed at the attack itself.
Yeah, and if you wanted to cut that off, you would either continue to talk about your injuries or you'd give the names. Because the point of all those questions is to help eventually find the attackers, and you've got their names.
Absolutely. But the victim
And then it's 24 hours before you give up the names.
That is correct. But the victim was never asked to specify the names of his assailants on the call.
But isn't that the main thing one would give up? Why are you saying that they're Dominican? Why are you saying the sweater they're wearing when this is the main thing that you would reveal? It takes more thought to remember the color of the sweater than it does to remember a person you know from high school.
When the police are called to initially investigate a crime, the names of the actual suspects is far less consequential than an actual physical description.
We're not talking about the police and the way they might think they would best investigate. You're talking about the person who's just been attacked.
Correct. But over the call, the complainant provides physical description of who his assailants are. All his answers are responsive to the inquiries directed to him by the dispatcher.
Okay, counsel, let me ask you if we can move now to the
Certainly.
lesser included. No, of course not. The lesser included. What is speculative about listening to testimony that someone is, for several minutes, being dragged up and down a staircase, up against railings, throws himself down a flight of stairs, pleads twice, please don't kill me, that in that melee, in that altercation, that's a very fast pace, that he might have been injured on the head in the course of that by hitting something? What's speculative about that?
What's speculative is the complete absence of any evidence adduced during the trial that would tend to show
But
that
why is it not an appropriate inference that when you're in an altercation where two people are pummeling you and you're going back and forth, being dragged up and down staircases, that you might actually hit your head?
Because that's inconsistent with the entirety of the testimony that was presented during the trial.
But of course, we've said that the jury could reject something and accept something else, and they might have decided that the people did not establish the use, excuse me, they established, excuse me.
Scarborough, I'm sorry.
Yes, let me just finish this point, thank you. Establish the use of a gun. So if they could do that, why can't they then, why isn't there enough? It's a low threshold to have enough reasonable evidence there to conclude that he might have hit his head against a staircase or the railing.
Because any such finding would not rest on any evidentiary basis. If I could direct this court to page 190 of the record, in which the victim explains the manner in which he came into contact with the stairs, and he states that he latched onto the handrail with his hands in order to prevent his assailants from continuing the attack by dragging him down the stairs.
But he's already been dragged up and down the stairs.
He's been dragged down the stairs at least once by this point.
But if this was a slip and fall case and the plaintiff said, I tripped on the stairs, I think there was a slippery object there, I have a head wound, wouldn't it be a fair inference that the head wound came from hitting your head on the stairs?
The problem in this case, Your Honor, is that there's no evidentiary hook. There's no evidentiary hook here that would bridge the jury to making this finding based on the evidence.
Of course there is. He's testifying that the head injury comes from a gun. They might discount that. But he's also testifying that this altercation has gone on over several minutes, back and forth, in this, up at the hallway, down at the hallway. He's fearful that he's going to be killed by these people. And then you have, of course, the doctor who says, yes, it's a hard, sharp object. I don't know what it's made of. I can't say it's made of metal, wood, or glass. And says, yes, it's consistent with a gun, but can't discount something else.
Right. Well,
It just strikes me as very odd for the people to argue that it would be so speculative that in this kind of an altercation, this kind of aggressive physical attack, that it's pure speculation that he might have hit his head on the staircase or the railing.
yes, Your Honor. But again, there still has to be an evidentiary link.
All right, let's say we disagree with you. I'm
Okay.
sorry, because I know you're going to run out of time, and I know my colleagues have many other questions,
Yes.
but I definitely want to get to this one, because I find this very difficult to figure out from the briefing. Let's say we disagree with you. Let's say it was error. Does the robbery count also, robbery counts also have to get reversed, or just the assault counts?
It wouldn't impact the integrity of the robbery convictions because those counts rest on completely different elements that do not overlap with any of the assault charges. And the jury was fairly able of parsing out the conduct that corresponded to the robbery and the assault
Well,
crime.
this will expose my ignorance about criminal law, but could he be remitted for sentencing on the lesser included without a new trial on the assault charge?
Your Honor, I don't know that off the top of my head, so I don't want to lead you astray.
Okay.
Counsel, could we just get back to one issue that Judge Wilson was asking your adversary about, which is on the kind of harmless error analysis. If this was precluded as an excited utterance, and the declarant who's testifying here, he is crossed on, there's a gun, you're saying there's a gun now. Could the statement from the 9/11 call that there was a gun come in as a prior consistent statement to rebut a charge of recent fabrication?
Your Honor, it likely could have come in under a different theory. And that, at that point, actually would dovetail with my response to the defendant's last contention in his brief. The fact that had this been excluded for whatever reason, we could have offered the statement, or at least portions of it, under some alternative theory, had the argument been appropriately
But
presented.
don't we have to decide this on the one exception you argued?
Correct, Your Honor.
So, I'm sorry. I don't know if you finished answering.
Oh, no,
Judge
I
Rivera,
had nothing.
But I have another question.
Yes.
So, what I want to understand is your view of how Scarborough applies to this case, or whether or not the appellant is correct that it's distinguishable.
Well, just as in Scarborough, there was no basis for parsing the victim's testimony, for selectively dissecting it, because his testimony was unwavering and consistent throughout. The 911 call largely corroborated his testimony. You have a straightforward, unfaltering version of events. So the jury was faced with the choice to either credit the version to credit it, or reject everything outright.
And
But I don't
what
understand
about
that.
the
I'm sorry,
medical
I'm not
testimony?
understanding that. Why would they have to reject, am I understanding you correct when you say reject everything outright, as in that there even was an attack?
Well, rejecting it to the extent that these defendants were responsible for the attack. I think everybody agrees that there was an assault.
Yeah, but then, I'm just finding it difficult. If he's acquitted on the top count of the robbery, right, so they're rejecting the gun.
Well, it's important to remember that this isn't a legally repugnant verdict, and we don't know why.
Not so persuaded, but they didn't
Right.
object to that, so we're kind of stuck with it.
They could have rejected the fact that while they were taking the phone from him, they didn't use the gun.
Correct. Right.
Right.
It was theoretically possible that he
Yeah, but my
committed the assault.
problem with your argument on
with
that,
the
I
weapon
know
and
you
not the
made
robber.
that argument in the brief, is that strikes me that you're parsing this. And you're parsing this. You're compartmentalizing, and you're arguing we shouldn't, right?
Well, all of us can do right now is surmise what took place
But
in
didn't
the
the victim
deliberation.
say they were kicking him and punching him during that time, so that it wouldn't be inconsistent with his testimony, would it? To say that they weren't hitting him with the gun while they were taking the phone?
Well-
That's consistent with his testimony.
Well, the doctor testified, Dr. Morris testified that the lacerations that he sustained to his head could not have been caused by punches or kicks, that they were consistent with a sharp object.
No, but what I'm saying is that this took place over a long period of time, so
Right.
that the injuries that he claimed were made by the gun may have been made during some other part in the melee, other than when they were physically taking the gun, or the phone from him.
Certainly what you're saying is hypothetically possible, but once again, it's not within the confines of the existing proof on this record. And I would just ask that this court affirm the order of the appellate division.
Thank you,
Thank you.
counsel.
Your Honors, there's no need to surmise anything here about what the jury was thinking. We note the jury passed up a note that asked whether the stairs or the railing could be considered a dangerous instrument. And that right there shows that there was some rational basis.
So let's say we agree with you. Can you address this question about whether or not all the counts get reversed or just the assault?
The prosecution's theory of the case on each of the charged counts here was that a gun was used during the course of a robbery. And I'd urge the court respectfully to look at this prosecutor's summation at A250 in the record, where the prosecutor marches through each of the elements to the jury of all of the robbery counts, including the robbery counts that legally don't require a gun, both robbery and the second-degree accounts. And the prosecutor said that the force element required for a forcible taking in each of those robberies was satisfied because, I quote, Brian hits him with the gun and Emmanuel takes his phone. The jury here was presented with a case in which a gun was inextricably linked to all of these charges. And without having had the option of choosing, of deliberating, even deliberating on assault in the third degree, which didn't require a gun, we don't know how the jury would have decided those counts. Those are factually related counts that should fall as well if there was a failure to include, to charge on the lesser included. On the 911 call,
Can you address Judge Wilson's question to your adversary about the sentencing?
I don't know, again, off the top of my head, Your Honor, about the sentencing. Our
I don't
position,
either. So we're in the same boat.
our position would be that there wouldn't, that failure to instruct on the lesser included here would require a new trial on all counts because of the way the prosecution chose to present this case to the jury. On the 911 call, in the people's
Your light
brief-
has gone off, so very quickly,
Sorry,
counsel.
the 911 call, the people rely on this call. They say they can sit down after they play it during summation, and the jury requests it 2 times. So any suggestion that the admission of the call was harmless error, we would disagree with. Thank you, Your Honor.
counsel. Thank you.